Now, what is the Federal Insecticide, Fungicide, and Rodenticide Act, or FIFRA? See, it's Title VII, Section 1336 of the United States Code, and it claims to regulate insecticides, environmental pest control. Remember, nothing in the Constitution delegates the United States the authority to regulate insecticides and environmental pest control. Congress can regulate interstate commerce, but only interstate commerce, not commerce within a state. But that didn't stop Congress from falsely claiming supremacy. FIFRA's preemption clause, entitled Uniformity, provides that a state shall not impose or continue to in effect any requirement for labeling or packaging in addition to or different from those required under this subchapter. FIFRA therefore preempts a state law labeling requirement that differs from the federal labeling requirements imposed by FIFRA. Now, according to SCOTUS, the Federal Insecticide, Fungicide, and Rodenticide Act, or FIFRA, not only preempts state labeling laws and, by extension, lawsuits in state courts regarding the labeling of products. What is the uniformity claim in FIFRA? Well, as quoted, such state shall not impose or continue in effect any requirements for labeling or packaging in addition to or different from those required under this subchapter. Congress, however, does not have the legal authority to tell states what laws they can pass regarding commerce within the state. That goes beyond the powers delegated to the United States. Federal law, therefore, requires Monsanto to sell Roundup with the label that EPA approved at the initial registration and that EPA has subsequently reapproved on multiple occasions, that is, the label without a cancer warning. Now, federal law can require that Monsanto sell Roundup with a certain label, but only in interstate commerce. The Constitution does not delegate to Congress the power to regulate intrastate commerce. Since Mr. Durnell sued under state law, this federal law does not apply. Meanwhile, as the court's precedent makes clear and as the parties agree, state tort duties constitute state labeling requirements. Durnell's state tort claim would require Monsanto to add a cancer label to its labels, which is in addition to and different from Monsanto's federal labeling obligations. Yes, Mr. Durnell's claim would require Monsanto to have an additional labeling in order to legally sell Roundup in Missouri. Now, commerce within the state of Missouri is an issue for Missouri state law. FIFRA's claim of supremacy fails constitutional muster, as Justice Thomas will get to in his concurrence. Durnell's counterarguments are unpersuasive. Durnell contends that a Missouri failure to warn claim, like FIFRA itself, simply requires manufacturers to include adequate warnings to protect human health and not to include false or misleading statements. But that argument operates at far too high a level of generality and disregards the central and comprehensive role the EPA performs in making labeling determinations under FIFRA's registration provisions. Except it was Congress who operated at far too detailed a level to pass constitutional muster. For example, except as provided by this subchapter, no person in any state may distribute or sell to any person any pesticide that is not registered under the subchapter. That language goes far beyond interstate commerce, but claims to dictate to states what they may or may not sell within their borders and under what conditions. Durnell argues that EPA's regulations and its procedures for registering pesticides and approving pesticide labels exceed or contravene EPA's statutory authority under FIFRA. Durnell is incorrect. FIFRA empowers EPA to prescribe regulations to carry out the provisions of FIFRA, Sections 136 WA1, and expressly directs EPA to register pesticides and determine that the pesticide's labeling complies with FIFRA's many specific requirements. What Durnell should have argued is that the FIFRA exceeded Congress's power to regulate interstate commerce and that the Constitution did not delegate to the United States the power to regulate pesticides, meaning that the legislation was not made pursuant to the Constitution, making FIFRA not only unconstitutional, but void. At least that's what the Supreme Court said in Marbury v. Madison, Ex parte Siebold, and Norton v. Shelby County. During the extensive registration process, EPA critically evaluates the pesticide labels to ensure that the label contains all warnings necessary to protect human health, and after EPA decides the appropriate warnings for a pesticide's label, a manufacturer is legally required to use that label unless and until EPA subsequently approves and requires a new label. Isn't the question of EPA's evolution of the pesticide label part of the question? The EPA claimed that all warnings necessary to protect human health were on the label, yet multiple studies seem to show at least the possibility, if not outright claim, that glyphosate exposure causes cancer. Since no one delegated to Congress the authority to anoint an executive agency with the power to determine what is and is not safe, they had no authority to supersede the states' rights to regulate commerce within their borders.